G'day folks. The title of this video is The Law of Nations, What is a Person? And clearly my intention here is to tackle the notion of person and try and bring some insight into what that is. Now, anyone who's got any interest in legal research will know that many people have tackled the notion of person before me. So the question would be, why cover the same ground that others have covered? Well, based on what I've seen of what others have covered, my hope is that what I'm going to do here is give a much more exacting and precise notion of what person is. Because my feeling is that while many other people have covered the issue of person and have got hold of something, I'm not sure in the end that anyone's really grabbed the bull by the horns. I think they've had the bull by the tail. They've been close, they've been around the issue, but I don't think anyone has been definitive and precise ultimately in explaining what the difference between man and person is. And it's my hope that by the time we finish this little study, you'll have a very exacting and precise knowledge of what a person is as juxtaposed against what a man is. So we're going to use a legal philosophy that's expounded in a text called The Law of Nations, which was written by a man called DeVattel. I believe he's Swiss, and he wrote it in about 1758. Now, what he wrote is the foundation upon which international law is based. So I'm just going to start now with a legal definition that clearly demonstrates that in the eyes of the law, man and person are not the same thing. In fact, it's pretty much going to say exactly that. So let's have a look at this. This is definition of person in Bouvier's Law Dictionary. And you'll see there, I've only highlighted one section because that's all I want to focus on at the moment. We will come back to this and look at something else later. But for now, I just want to make this point. In law, man and person are not exactly synonymous terms. So to be clear, what this is saying is that the term man and the term person do not mean the same thing. So what I just want to say here is that in this definition they say they are not exactly synonymous. How substantive you find the difference in them to be is really a subjective matter. But we'll find exactly what the differences are as we go through. So let's now set that aside for the moment, and I'll just now show you the Law of Nations. This is the, I'm just showing you this because it's the cover page. This is the first page from the Law of Nations. Now the Law of Nations, written by DeVattel, comes in 3 books. The first book is called Preliminaries, and is a sort of introduction to the topic. And then there's 2 other books on it. So the information we're going to look at here is just one small chapter from the preliminaries. I just now want to look at an extract from Wikipedia on the Law of Nations, what it says about it. And we'll just read the highlighted bits. These are just extracts from the wiki page. The Law of Nations is a legal treatise on international law by Emeric DeVattel, published in 1758. The Law of Nations has been said to have modernised the entire practice of international law. The entire practice of international law. So not an insubstantial document. Influence. United States Presidents George Washington had the Law of Nations. Benjamin Franklin presented one copy to the Library Company of Philadelphia. Franklin also said that this book by Vattel has been continually in the hands of the members of our Congress now sitting. It, being the Law of Nations, it provides at least a partial legal basis for the modern conscription in the United States. In the Selective Draft Law Cases, 1918, upholding the Selective Service Act of 1917. And I'm just going to quickly now go to what Wiki says about the Selective Service Act of 1917, which dealt with the issue of conscription. From Again, extracts from Wiki on the Selective Service Act of 1917. The Selective Service Act of 1917 authorised the United States federal government to raise a national army for service in World War I through conscription. The Selective Service Act was upheld by the United States Supreme Court. The Solicitor General's argument and the Court's opinion were based primarily on Neil v. Lane and Vattel's 1758 treatise, The Law of Nations. So this has been used to uphold the state's right to conscript persons. All right, so let's now take a look at the chapter I want to focus on from the Law of Nations. And that is, well, not the chapter, the section, I should say. It's section 4. In what light nations or states are to be considered. Now, I just want to preface this by saying DeVattel, in this treatise, when he uses the term man or men, and when he uses the term person or persons, he uses them precisely. He doesn't use them indiscriminately. He doesn't use them casually. When he uses the term man, he means something very specific, and when he uses the term person, he likewise means something very specific. And we'll see that as we read these excerpts from this section. Or actually, I'll read the whole thing and then we'll look. You'll notice too that I have highlighted a section in red and I've highlighted another section in blue. What you will find if you examine them closely is that the section in red is DeVattel's thoughts on man, and what's highlighted in blue is DeVattel's thoughts on person. Okay, so in what light nations or states are to be considered? Nations being composed of men naturally free and independent, and who before the establishment of civil societies lived together in the state of nature. Nations or sovereign states are to be considered as so many free persons living together in the state of nature. It is a settled point with writers on the natural law that all men inherit from nature a perfect liberty and independence of which they cannot be deprived without their own consent. In a state, the individual citizens do not enjoy them fully and absolutely because they have made a partial surrender of them to the sovereign. What are they partially surrendered to the sovereign? Their perfect liberty and independence. And I do take issue with what DeVattel is implying there. What he said is technically correct, but where he says a partial surrender, I would like to suggest to you that there is no such thing as a partial surrender of sovereignty. Sovereignty is absolute, and to surrender any part of it is to surrender it in total. But I'll expand on that thinking towards the end of the video. But just hold that in your mind for now. Alright, so now what I want to just put before you is those same sections we just read that were highlighted in red and blue, putting the two sections that were in red and refer to man together, and putting the two sections that were in blue together which referred to persons. So if we put them together, this is what we can say about men based on what DeVattel has written. Men, naturally free and independent, who before the establishment of civil societies lived together in the state of nature. All men inherit from nature a perfect liberty and independence of which they cannot be deprived without their own consent. Persons, with respect to persons, sovereign states are to be considered as so many free persons living together in the state of nature. In a state, the individual citizens do not enjoy them, that being liberty and independence, fully and absolutely, because they have made a partial surrender of them to the sovereign. I just want to now distill further from what we've just read what DeVattel's saying about men and what he's saying about persons. So men are naturally free and independent, having inherited from nature a perfect liberty and independence of which they cannot be deprived without their own consent. That's what he says about men. And when it comes to persons, he says, he's effectively saying persons do not enjoy liberty and independence because they have, by consent, made a partial surrender of them to the sovereign. And I think that's just self-evident. If men cannot be deprived of their perfect liberty and independence without their consent, and if a person is deprived of perfect liberty and independence, they must be deprived of it by their consent. So a person, by derivation, must have consented to surrendering their sovereignty to another. Okay. Let's now go back to that definition of person that we were looking at from Bouvier's Law Dictionary. And as you can see, originally we had highlighted there, in law, man and person are not exactly synonymous terms. Well, now we just look at this other section from it. A person is a man considered according to the rank he holds in society. Well, that ties in quite nicely, I think, with what DeVattel was saying. I'd even suggest it may be drawn from what DeVattel wrote. Because DeVattel, to me, is clearly distinguishing, one of the distinctions between a man and a person is that a man is outside society and a person has come inside society, but in order to get into society has had to relinquish their sovereignty. And they've relinquished it to the collective sovereignty. However that's administered, whether it's administered through a monarch, through a cabinet, through a parliament, through a congress, through a president, it doesn't matter how it's administered. Fundamentally, a person is someone who, in order to gain the benefits of being in a society, has relinquished their individual sovereignty by consent. It must be by consent, as DeVattel clearly states. What else does it say there? A person is a man considered according to the rank he holds in society. Well, what's the rank that a person has? Let's go and have a look at a definition of rank from a law dictionary. Let's first look from Black's Law Dictionary. As you see highlighted there, rank is often used to express a title. So obviously title is relevant. Now I'll just say with respect to title, title has a number of meanings. There's land titles, so title as it relates to the term land, titles of books, and then there's titles as they're applied to persons. So we're going to focus on titles as they are applied to persons because clearly that's what's relevant here. And as we see here, in the law of persons, meaning as the term title applies to person, a name denoting the social rank. So a title, as it is relevant to the notion of persons, is a name denoting social rank. And then we see here in Bouvier's title, again as they relate to persons, titles are distinctions by which a person is known. So a title is a rank or distinction applied to persons. Can a title be applied to a man? Well, I'd like to suggest that it cannot. Because as is recognised in the US Constitution, in the preamble, all men are created equal. So men can't have ranks amongst themselves, because to have a rank is not to be equal. A rank places someone above and someone beneath.